This is passage number 19. Duration 6 minutes, speed 100 words per minute. Dictation starts now. Gender equality is not just a fundamental human right but a necessary foundation for a peaceful and prosperous society. Over the last few decades, we have seen a significant increase in the participation of women and various professional fields, ranging from corporate sectors to the armed forces. However, this progress is often hindered by the persistent issue of sexual harassment at the workplace, which creates a hostile and intimidating environment for female employees. The present writ petition is filed by a senior executive who was terminated from her services shortly after she lodged a formal complaint against her superior under the provisions of the Sexual Harassment of Women at Workplace Prevention and Redressal Act. Para. The learned counsel for the petitioner argued that the internal complaints committee of the respondent company failed to conduct a fair and impartial inquiry as per the statutory guidelines. He submitted that the committee members were directly under the influence of the accused officer, which led to a biased report. It is further contended that the principles of natural justice were violated as the petitioner was not allowed to cross examine the witnesses produced by the management. The council urged that the right to work with dignity is an integral part of the right to life under Article 21, and the sudden termination of the petitioner is a clear case of victimization. Para. On the other hand, the learned counsel, appearing for the respondent corporation, submitted that the termination was purely based on the poor performance of the petitioner and had no connection with her complaint. He argued that the internal committee had followed the due process and found the allegations to be baseless and motivated by professional jealousy. The corporation maintains that they have a zero tolerance policy towards any form of harassment and have already established a robust mechanism to address such grievances. According to the respondents, the petitioner is using the law as a shield to hide her professional incompetence and to seek a heavy compensation through litigation. Para. We have perused the inquiry report and the service record of the petitioner. It is a well settled law that the safety and dignity of women at the workplace cannot be compromised under any circumstances. The enactment of the POSH Act was a result of the landmark directions issued by the Honorable Supreme Court in the Vishaka case to fill the legislative vacuum. The purpose of this law is to provide a safe working environment and to encourage women to report any misconduct without the fear of losing their jobs. If an employer uses termination as a tool to silence a complainant, it defeats the very purpose of the legislation. Para. Furthermore, the courts must adopt a sensitive approach while dealing with such matters. The burden of proof in departmental inquiries is based on the preponderance of probabilities and not on the strict proof beyond reasonable doubt. We find it strange that the petitioner, who had an excellent track record for 10 years, suddenly became an underperformer immediately after filing the complaint. This sequence of events creates a strong suspicion regarding the bona fides of the management. Justice must not only be done but must also be seen to be done. A workplace that does not respect its female employees can never achieve true professional excellence in the long run. Para. In view of the aforesaid facts, we set aside the termination order and direct the respondent company to reinstate the petitioner with full back wages and continuity of service. We also direct the constitution of a fresh inquiry committee consisting of an external member from an NGO to re-examine the original complaint. The petitioner shall be provided with all the necessary protection during the course of the inquiry. The company is further directed to conduct gender sensitization workshops for all its employees within 3 months. With these directions, the petition is allowed. No order as to costs, all the connected application stand disposed of. The parties are at liberty to move the appropriate forum for any further clarification required. Over. Stop.